Right, so we are going to get started. So good morning, I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Kyle Daniels, inmate number 380907. Today is Thursday, May 21st, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Cybulski Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Kyle Daniels, 380907.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones from the Public Defender's Office on behalf of Mr. Daniels.
Thank you. And also present this morning is your charging officer. Can you please identify yourself for the record?
Yes, good morning. Parole Officer Patrick Davis. I work out of the Hartford District Office and I supervise Mr. Daniels.
Thank you.
welcome.
So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that, more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Daniels and Officer Davis, can you both please raise your right hands? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
I do.
Thank you. So we're going to go over the procedure for today's hearing. So first I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find that you violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. And after the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, I did.
Do you have the right to review the evidence against you before this hearing? You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
All right, so we are now going to review the charges that the state, your parole officer, is bringing against you, and the information underlying that charge. So, Officer Davis, can you please review the charge for us? Number one, obedience to the law.
Sure. Obey all laws. Charge number one, obedience to the law. On Friday, November 28th, 2025, at approximately 10:12 p.m., Hartford Police Department responded to an address in the city on a report of a domestic dispute. Upon Hartford Police Department's arrival, officers met with the victim, who stated she was assaulted by her child's father. Victim stated that the night prior at approximately 10 p.m., you started to call the victim multiple times. Shortly after, victim stated you entered her residence as the back door was left unlocked. It should be noted that the victim did not let you in. Once you were in the residence, you began walking around to various rooms in the residence, appearing to look for somebody else. Victim stated that you and her began to argue, and you proceeded to grab her throat with both hands and squeeze. Victim stated that she was unable to breathe at this time. You continued to yell at victim, and you struck victim in her head with an open hand. When talking to the officers, you could clearly tell the victim was nervous, as her hands were shaking and she was stuttering. Victim also had redness and swelling to the left side of her face near her eyebrow. You and the victim were involved in a domestic violence incident. Subsequently, you were charged with CGS 53A-010 burglary first degree, 53A-64 BB strangulation second degree, 53A-61 assault third degree, and 53A-182 disorderly conduct. You were arrested by Hartford Police Department and seen in court at Hartford GA 14 and bonded out as no contact was made to this parole officer. You have a bond of $75,000 and a next court date of 03/04/2026 under docket number H14H-CR26-0775230-S.
Thank you. You've also submitted evidence in support of the charge. Can you please identify the evidence for us?
Sure. Exhibit A, evidence, signed statement of understanding, agreement, conditions of parole. Exhibit B, remand to actual custody order. Exhibit C, parole violation report, notice and parolee rights. Exhibit D, parole violation report. Exhibit E, arrest warrant application, Hartford Police Department, case number 25-027900. Exhibit F, BOPP decision information summary. Exhibit G, Connecticut State Judicial Case Lookup Printout.
Thank you. And you've also submitted an addendum to the parole violation report, and that was submitted on April 22nd, 2026. Can you please review that for us?
Sure. Addendum, Mr. Daniels was seen in court on 04/16/2026 at Hartford GA 14, and the following dispositions occurred under docket number H14H-CR26-0775230-S. CGS 53A-101 burglary first degree, Nollied 04/16/2026. CJS 53A-64 BB strangulation second degree, Nollied 04/16/2026. CGS 53A-61 assault third degree, guilty, 11 months jail, execution, suspend, 1 year, conditional discharge, 04/16/2026. CGS 53A-182 disorderly conduct, Nollied 04/16/2026. Mr. Daniels does not have any pending fees or fines, and BOPP may proceed with revocation hearing at this time.
Thank you. Counsel, to confirm, you and your client did receive the parole violation report, the notice of parole violation, and all the other documents identified for today?
Yes.
And then I did receive one exhibit from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
No.
Do not have any witnesses. So at this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted. So Officer Davis, any comments at this point towards the charge?
I was surprised when these charges came down on Mr. Daniels. With me, he always has been polite, respectful, reports on time. Been out to his house for multiple home visits. Residence is clean. Since I started this position, Mr. Daniels has been one of my, for a lack of a better term, best parolees. Pretty much all I have.
Thank you.
Yep.
I appreciate your statement. And counsel?
Yes, thank you. I have no comments other than just to indicate that the addendum was stated accurately. I just would like to be heard on his background and history. Thank you.
Thank you. I'll just take a moment, then I'll announce my findings.
Oh, I will say too that Mr. Daniels was working full time and was working his way into the laborers contractors union. He was working over 40 hours a week. And I'm not sure if I'm going to be able to speak again, but the only issue that I have is housing. So he may have to start back at a halfway house and work his way out to scattered site housing again. That's all I got.
Yeah, we can collect more information if we move on to that second part, whatever you
Gotcha.
need. Great. So Mr. Daniels, I am gonna announce my finding in regards to the charge. So I have identified the charge as separate parts and each offense identified as its own part. So I'm making a no finding for the charge of burglary first, as none of the evidence, or there's an insufficient amount of evidence to support that behavior and that crime occurred. I am making a finding for the charge of assault third based on your conviction on April 16, 2026, when you received that sentence of 11 months jail, execution suspended, followed by 1 year of conditional discharge. In addition, although the other charges were nullied, I'm also making findings on the strangulation and disorderly conduct. And in total, the evidence that supports these findings are states exhibits A, D, and E. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, the state will have an opportunity to speak more onto your background and history if they choose to do so. Once he is concluded, you will also have the same opportunity. The point and purpose of this part of the revocation hearing is to help determine what outcome I recommend. So Officer Davis, anything additional about Mr. Daniels' background and history?
Yep, I just wanted, like I mentioned before, just the employment, and then I don't think he has anywhere to sponsor out to when he does get discharged. So like I said, halfway house, and then transition him out to the state-funded scattered housing would probably be in his best interest. That's all I have.
And you did mention, just to, I wrote it quickly, sorry, Officer Davis, he was working full-time and into the labor units?
Yes, I believe, yep, laborers and contractors union. Yep. Employed full-time, over 40 hours a week,
Thank
and
you.
provided pay stubs for proof.
Okay, thank you. And counsel?
Yes, thank you. My client is 32 years of age. He's single. He does have 5 children, all of whom are minors who reside in the state of Connecticut. He receives his primary support in the community by way of his mother, his 3 sisters, brother, and extended family. He did complete his GED while he was incarcerated. He did report to me that he was in the construction laborer union, did receive his OSHA 10 certificate as well. He was in the community, released to supervision on August 25th of 2023. So I believe that's approximately 2 years, 5 months. I believe this to be his first violation of his parole. And during the time period that he was in the community, he was first released and successfully completed the Open Hearth Halfway House program. I believe he was on GPS monitoring and successfully completed that as well. He then utilized the Chrysalis Center scattered house housing program as well. He, as his parole officer has indicated, he received no misconducts or sanctions while he was in the community, and he was fully compliant with his parole conditions up until the point of this arrest and remand. He was gainfully employed, working Charter Oak Utilities in Hartford for almost 2 years, and again, working over 40 hours weekly. He was compliant with his court-ordered child support payments, having that money directly withdrawn from his paycheck. Regarding his court case, again, it is unfortunate. He was in an 11-year relationship with this individual. They do have 2 children in common. He did indicate to me that he entered into the plea agreement, certainly because he wanted to resolve that matter rather quickly so he can be presented here for his hearing. He has no history whatsoever of domestic violence. He would have been program eligible. However, again, he elected to enter into the agreement so that he could be here today and have this hearing at a quicker time period. Upon reinstatement to parole, he does ask to be sponsored by his mother, Gladys DeJesus, and he provided her address, which is contained within Defense Exhibit 1. Certainly amenable to a halfway house if that is not feasible to go to his mother's address. However, I did not discuss a halfway house area with him. So, Mr. Daniels, can you just indicate if you had to go to a halfway house, which area you would like to be in?
Hartford will be perfect.
Okay. So if he does have to go to a halfway house, he's asking for a halfway house in the Hartford area. He does have his employment to return to at Charter Oak Utility Construction as well. He's amenable to all treatment recommendations, and certainly that's inclusive of domestic violence programming. He is looking to return to the community, reunite with his children, continue supporting them. As he was doing. I would note again that my client had no history of domestic violence, not even an arrest for domestic violence. He would have been program eligible in that matter, having never used that program before. He does have on his record, he does have 8 convictions, and I just want to note what they are because none of them are violent, but for the offense that he just pled to, the assault third, which one could classify because it's domestic violence. However, he has a sale of narcotics with a violation of probation that is nonviolent, a larceny 4, a larceny 3 with a violation of probation, again, nonviolent, 2 operating under suspensions, and then a criminal possession of a firearm, for which he is on parole right now. That is obviously classified as well as a nonviolent offense. So I just think that's important to note that he has no history of violence. So we would be asking that he be re-paroled at the next available board review date. I know he's been in custody now for 4 months. I know his parole officer was in the recommendation section had indicated a recommendation of 6 months. I don't know if that had changed after the disposition in court, which was included no jail time and was a conditional discharge. I do think that's appropriate in light of all of the circumstances. For him to be re-paroled at the next board review date. And again, he's very eager to get back out to his work and to continue to support his children. Thank you.
Thank you. Any additional comments from either side before I do make my recommendation?
Mr. Daniels, is there anything you'd like to add?
Yes, so I'd like to add that I have a few goals I want to go over. Is that okay?
Yes, of course.
Okay, yeah, so for my first goal, I want to take full advantage of the DV program once I'm released into the community. I want to actually learn something that I can take and teach my 3 boys so that way they never end up in this situation. And for my second goal, I would like to get back out there as soon as possible, get back to work, move up in the chain so that way my kids won't need anything. Right now, their moms don't have a job, so I'm literally like the only one that's taking care of them. And due to the fact of me being in here, their life isn't as well as they want it to be. I miss my son's birthday and my daughter's birthday, which we had big plans on doing good things, but me being in here, the birthdays wasn't fulfilled the way they wanted it to be. For my third goal, I would like to take the first step when I'm released and go to the courthouse and get visitation rights for my kids so that way I will never have another misunderstanding with his mother and I won't be put in this place again.
Thank you, Mr. Daniels. I appreciate your statement. Anything further, anything additional from you, Officer Davis?
No, I'm willing to, investigate his mother's address if that's where he wants to go. I have nothing else to add.
Counsel?
No, nothing further. Thank you.
So I have listened to the testimony today. I've also reviewed all the evidence provided. As stated on the record by both sides, it seems like Mr. Daniels was doing pretty well out in the community up until this event and working full time. So that's important. So, Mr. Daniels, I'm going to recommend your parole be revoked and that you serve an approximate 4.5-month sanction. That's with a re-parole date of June 4th, 2026. I'm going to recommend the following conditions: behavioral management program for domestic violence, a general no contact with nails by the corner and on Farmington Avenue in Hartford, Connecticut. Can you confirm the victim's initials? Is it JG?
JG, yeah.
That's her initials? Okay. I'm also going to do a general no contact with JG without your parole officer's permission, okay? So you make sure you speak with Officer Davis before you have contact with her, whatever you guys work out. But don't, it's going to be at his discretion and what he believes is best for your situation, okay?
Yes.
Officer Davis, would you like me to do the halfway house placement or should we just roll with the sponsor?
I think at halfway house placement or condition would be good, just in case the addresses don't work out. If he does have all that support of his brothers and sisters and mother, I just question on why he didn't discharge there previously. So I'm good with either way. If an address works out in the community, I'm fine with that. If it doesn't, I think halfway house and then scattered site.
Okay, so I'll do a halfway house placement stipulation as well.
Yes,
I'll
please.
recommend that.
Thank you.
Thank you. So what happens next, Mr. Daniels, is that my recommendation is going to go to the board on June 4th. On that date, the board can only do two things. They can adopt the recommendation and release you that day. And then if for any reason they would want to see a longer period of confinement, they'll ask you to come back for another hearing to address any other questions and concerns before anything longer is imposed. Okay. Do you have any questions right now, Mr. Daniels?
As of right now, no.
So this does conclude today's hearing, and we are going to go off the record. Thank you, everybody.
Thank you. Good luck,
Mr.
Kyle.
Daniels.
Thank you, Mr.
Thank you.
Daniels. Good luck. I'll see you soon.
Appreciate it.
Yep.
Morning.
Good morning, how are you?
Which one would you like first?
If you have Mr. Lopez, that'd be great.
Okay. Lopez.
Good morning, Mr. Lopez, how are you?
All right.
We just have to wait 1 minute and then we can get started, okay?
Okay.
Good morning, I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Hector Lopez, inmate number 217395. Today is Thursday, May 21st, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Hector Lopez, 217395.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones from the Public Defender's Office on behalf of Mr. Lopez.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Lopez, can you please raise your right hand? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, to help you God upon penalty of perjury.
Yes.
Thank you. So we're going to go over the procedure for today. So first I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So you have important rights. We're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
We'll now review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So on charge number 1, the condition of search, the charging officer reported that on 4/26/26, Halfway House staff found you in possession of 3 cell phones. However, you were only allowed to possess 1 cell phone per resident in the Halfway House, as stated in their rules. In addition, according to the Halfway House staff, you intentionally damaged one of the phones, which caused it to catch fire and it became inoperable. Because the cell phone was destroyed, based on your actions, the phone could not be searched by Halfway House staff or parole. Based on this information, you violated the search parole condition. On charge number 2, the condition of Halfway House placement, the charging officer reported that on 1/22/26, Halfway House staff found that you were unaccountable in the community for 40.5 hours during the week of 1/9/26 to 1/16/26, based on the pay stubs you provided and community passes turned in by you. On 1/4/1/26, Halfway House staff found that you were unaccountable in the community for 7 hours during the week of 3/8/26, 3/21/26, based on the pay stubs provided by you and the community passes turned in by you. On 4/26/26, Halfway House staff found you in possession of 3 cell phones. However, you're only allowed to possess 1 cell phone per resident, 1 cell phone per resident in the Halfway House. On 4/26/26, Halfway House staff found you in possession of 3 cell phones. However, you're only allowed to possess 1 cell phone per resident in the Halfway House as stated in their rules. In addition, according to the Halfway House staff, you intentionally damaged one of the phones and caused it to catch fire. Because the cell phone was destroyed based on your actions, the phone could not be searched by Halfway House staff or Parole. On 4/27/26, the Assistant Program Manager, Jessica Rivera, wrote a letter requesting your removal from the program based on continued noncompliance and safety concerns that affected the whole program, staff, and residents. Based on your termination from the program, you violated the Halfway House agreement and were negatively discharged. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the parole conditions, Exhibit B, the parole violation report, Exhibit C, the notice of parole violation, Exhibit D, the remand to custody order, Exhibit E, the DOC Halfway House agreement, Exhibit F, the incident report dated 1/20/26, Exhibit G, the incident report dated 4/1/26, Exhibit H, the misconduct report dated 4/2/26, Exhibit I, the residential program electronic device disclosure form, Exhibit J, the letter from Assistant Program Director, Exhibit K, the letter of destroyed cell phone A, Exhibit L, the picture of destroyed cell phone B, Exhibit M, the picture of destroyed cell phone C, Exhibit N, the statement from Lopez, and Exhibit O, the incident report dated 4/28/2026. Council, to confirm you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today.
Yes.
And I did not receive anything from the defense at this time. Do you need time to submit any documents, counsel?
Not at this time.
Do not have any witnesses. So at this time, it is the defense's opportunity to respond and make a short statement and testify with respect to probable cause and the severity of the allegations. So counsel?
Yes, thank you. In regards to charge 1 search, we would submit there's insufficient evidence to support a finding of probable cause, as there's no evidence that was submitted that my client was asked to turn over the phone. He was asked to provide a passcode for the purposes of a search. In fact, the allegation is that my client was not compliant with Halfway House rules, namely that he was not allowed to possess more than 1 phone. The elements of the offense require that my client be instructed to submit to a search and also require that he then not submit to that search as instructed. So we would submit that there is insufficient evidence to support a finding of probable cause as to the search charge. Nothing further at this time as to the remaining charge.
Thank you. So, Mr. Lopez, on charge number 1, as I am making a note finding a probable cause, as counsel stated, there was no instructions or no evidence to prove that you were given instructions to submit to a search and that you failed to do so. And on charge number 2, I am making a finding of probable cause for the condition of Halfway House placement based on the evidence presented in states exhibits A, B, E, F, G, H, J, N, and O. I am also finding out the acts are serious enough to warrant a revocation, and I've also determined that you should be detained while you await that revocation hearing. So we'll notify the records office at the facility and let your officer be aware of it. So what happens, Mr. Lopez, is we'll schedule that revocation hearing within the next 60 business days of your remand to determine whether or not you have violated your parole. If there is a violation found, the hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So that does conclude today's matter. Do you have any questions?
I wanted to say about the cell phone situation.
So I will advise you to save those comments for the next hearing. Obviously, that's your choice, but that would be my advice to you.
Okay.
We'll try to get you in sooner than later. It won't be so far out. Probably in the next few weeks. Okay.
Yeah. All I wanted to say, I followed all the rules when I was there and I was working and doing what I was supposed to do.
Yeah. Well, like your attorney said, you guys will address it more. I think she'll speak to you before then, possibly. I don't know what she's going to do, but
correct.
We'll address it more at the revocation hearing. Okay. All right, this concludes the preliminary hearing for Hector Lopez, inmate number 217395. Thank you, Attorney Jones. Good luck. We'll see you soon, Mr. Lopez, okay?
Thank you. Hector, I'll schedule a legal call with you, okay?
All right, thank you.
All right, you're welcome.
For the next guy?
Yes, please.
All right.
Thank you. Morning, Mr. Neal. How are you?
Good morning, thank you.
Get started in a moment. All right, so good morning. I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Michael Neal, inmate number 176673. Today is Thursday, May 21st, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
It's Michael Neal, number 176673.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. As this morning is your attorney, can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Neal. Good morning.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of fact as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better weight of your evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to an appropriate sanction. A recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Neal, can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for today's hearing. So first I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Right, so you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
I did, yes, ma'am.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
So we're now going to review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So in charge number 1, the condition of obedience to the law, the charging officer reported that on 2/17/2026, the Wethersfield Police Department was conducted a well-being check and observed you walking in the roadway and stumbling. Upon the officers approaching you, you provided the name Michael Broffelli. The officer asked again, and they were not able to confirm your identity, which you stated, Michael Neal Broffelli. You eventually provided your proper name, Michael Neal, to the officers. A search of your name revealed that you had absconded from the halfway house, and officers made an effort to detain you. You were instructed to sit on the sidewalk, to which you refused. You began pacing, showing difficulty balancing, mumbling, and rambling. You were instructed again to sit on the sidewalk, to which you refused. At that time, you backed up into the guardrail, flipped over it, and rolled halfway down the hill. At that time, you got up and fell again into a snow pile. Officers instructed you to stop eluding them, and you yelled, "Fuck you," and continued down the hill. You threw yourself against the dumpster, fell again, and at that time, officers attempted to detain you, to which you refused to give the officer your hand and resisted arrest. The officer was eventually able to safely secure your wrist restraints, and you were transported to Hartford Hospital. Due to your actions, you were found to be in violation of Connecticut General Statute 53A-167A, interfering and resisting. Charge number 2, condition of drugs. The charging officer reported that on or around 1/15/2026, he voluntarily admitted to use of non-prescribed Suboxone. And on charge number 3, the condition of halfway house placement, the charging officer reported that on 2/14/2026, Around 10:50 p.m., you walked out of the front door of the Watkinson Halfway House without authorization with 2 bags. You proceeded across the street and get into a truck. You did not respond to attempts to call your cell phone, and you did not return to the Watkinson Halfway House. Your whereabouts in the community were unknown until you were arrested by the Weathersfield Police Department on 2/17/2026. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the Notice of Parole Violation, Exhibit B, the Notice of Parole Rights, Exhibit C, the Remand to Actual Custody Order, Exhibit D, the Parole Conditions, Exhibit E, the Halfway House Agreement, Exhibit F, the Voluntary Admission of Positive Test Results, Exhibit G, the Offender Misconduct Report, Exhibit H, the Community Solution Inc. Incident Report, Exhibit I, the Community Solution Inc. Abscond Report, Exhibit J, the Weathersfield Police Department Case Incident Report, Exhibit K, the Misdemeanor Summons, Exhibit L, the Decision Information Summary, Exhibit M, Revocation Summaries, Exhibit N, the Parole Violation Report, Exhibit O, the Disciplinary Report, and Exhibit P, the State Police Report. So in addition, the state did file an addendum to the Parole Violation Report on April 27, 2026 that states that on April 24th, 2026, a disposition was reached and you were convicted of interfering and resisting and received an unconditional discharge. Off note, Neal was returned to DOC custody on 2/17/2026. On 2/20/2026, he was found to be in possession of a controlled substance and therefore received a disciplinary report for contraband A, as well as an arrest for Connecticut General Statute 21A-279A1, possession of a controlled substance, and Connecticut General Statute 53A-174A, conveying unauthorized item into the institution. Disposition for these charges was reached on March 9th, 2026, and you did receive an unconditional discharge. DOC disciplinary report. Sorry. And the state police arrest report was also attached, and they were ready to proceed with the revocation. Counsel, can you confirm that disposition for me? It says that he was given unconditional discharge for both charges.
Yes, that's accurate. I actually have it pulled up and I could send this over email if it's helpful, but I'm looking here, docket ending in 966. This is the case out of G14. It looks like a nollie was entered on the charge of unauthorized conveyance, and there was just a guilty plea for the unconditional discharge on the possession. And then in the other matter, docket ending 437, New Britain matter, that was an interfering unconditional discharge. I don't remember if there were other charges, but if there were, those were a nollie as well.
Okay, thank you.
Yes, absolutely.
Okay, and just to confirm, counsel, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we have. Thank you.
Perfect. And I did receive an exhibit from the defense. I have Exhibit 1, a list of parole accomplishments and future plans for parole during the statement. Counsel, do you need time to submit any other documents?
No, I don't. Thank you.
Don't have any witnesses. So at this time, it is the defense's opportunity to present evidence and speak to any of the evidence submitted. So counsel?
Yes, just very briefly, really no comments aside to know the, disposition that we had mentioned was accurate. 2 unconditional discharges are what he received on misdemeanors. No additional supervision was ordered or time to serve. And I believe all other remaining charges, nollies, were entered. We would at the appropriate time like to speak to my client's background and history as well. Thank you.
Thank you. Okay. So on charge number 1, Mr. Neal, I am finding that you violated the condition of obedience to the law based on that conviction of the interfering and resisting on April 24th, 2026, and you received an unconditional discharge. In addition, the evidence in support of that charge states Exhibits D, J, and N. I'm making a no finding for charge number 2, the condition of the drugs, because the behavior occurred prior to your starting active supervision per the evidence submitted by the state. On charge number 3, I'm making a finding that you violated the condition of halfway house placement based on the evidence presented in states Exhibits A, E, H, I, and N. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, I'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I recommend. So counsel?
Yes, thank you very much. My client, Mr. Neal, was born in Putnam, Connecticut, raised in Wallingford. His support in the community includes his brothers and sisters-in-law, and then also his fiance. He does report his fiance having recently been diagnosed with cancer and is, I believe, in very poor health, and he is very anxious to get back and help her. They are planning to marry as soon as possible, and he does have a stepchild with his fiance. Most recently, my client utilized Watkinson Halfway House. Previously, he successfully completed Eileen O'Connor House and utilized the REACH program and Chrysalis Scattered Site program. Most recently, he was actively searching for work. He was reportedly in the process of returning to Fresh Point in Hartford. He does have prior work experience through Fresh Point and at Wood and Tap in Hartford. Most recent treatment, he had done an outpatient intake and started services with Wheeler Clinic. He reports prior treatment at Rushford, CHC, and the Institute of Living. He reports since being incarcerated, he's been on the wait list for work and programming. Upon reinstatement of his parole, he would like to be placed at a Hartford area halfway house due to proximity to his job. He hopes to successfully complete the halfway house and then move in so that he can help care for his fiance. He is able to return to Fresh Point, and that is his plan to try and get employment back there. He is eager to care for his fiance, as I noted, who could very much benefit from his help. And he's open to any sort of treatment being recommended, including going back to Wheeler Clinic for services. I'm asking that you would consider a 4-month sanction for my client. He has been incarcerated since February of this year. And as I noted, I know he's very anxious to get home and continue moving forward with parole. Mr. Neal, is there anything I didn't cover concerning your plans or your background that you want to say?
I don't think so. I think you did a very good job for me. Thank you very much.
All right. Thank you.
Thank you. I'll just take a moment, then I'll announce my recommendation. So I do just want to note some things for the record. I listened to the testimony today, reviewed all the evidence. This is Mr. Neal's second violation on special parole. He does also have one top placement referral that he completed in 2024, and he was only out in the community for approximately 1 year between his release and into custody, and he received a misconduct during that time. He also did receive the new convictions, both of them, and I am taking into consideration the one that he wasn't violated on as part of the sanction for today's hearing. So I am acknowledging that he also was convicted of the possession of the controlled substance. Community Services has requested a 1-year sanction or recommended a 1-year sanction. Mr. Neal, I'm going to recommend that your parole be revoked and that you serve an approximate 6-month period of confinement as a sanction. That's with a re-parole date of August 17th, 2026. I'm going to recommend the following conditions. No consumption of alcoholic beverages, no contact with the victim of your friend's DJ's family, general no contact with SM, mental health treatment, and we're going to do a halfway house in Hartford, correct?
Yes, ma'am.
Hartford. Okay. All right. So that is my recommendation, Mr. Neal. What happens next is that it's going to go to the board on June 4th. What happens on that day? The board can do 3 things. They can lessen my recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a period of confinement longer than what I've recommended, they'll ask you to come back for another hearing to address their questions and concerns before anything longer is imposed. Okay?
Okay. Thank
Do you
you.
have any questions?
No, no, ma'am. Thank you.
So this does conclude the ratification hearing for Michael Neal, inmate number 176673. Good luck to you, Mr.
Thank
Neal.
you.
Thank you, Attorney Dean.
Good morning, attorneys and PO Benick. I'm not sure if Gerard are still connected, but we did lose internet here, and there was also a state outage that New Haven and Hartford reported. Since BOPP is back up, I am going to try and connect to New Haven and see if they are back up.
Thank you.
Hi, I'm here. I had to go on my VPN, so hopefully it stays on. But we'll
Yeah, I
see
didn't
what
check
works.
with Garner just yet. I know that you were connected, and if we can connect to New Haven and Hartford, we will probably still go in order. But I
Okay.
just wanted to let you know that there was a state outage with the network.
Yep, I know. All right, perfect. Thank you.
Thank you.
Kristen, so has New Haven been able to get him?
They haven't answered the call yet.
Okay. So Attorney Dean,
Hi.
so we're, I don't know if you heard Kristen, so what is it? New Haven's not answering the phone call. They were also down. So I don't know if they're still trying to get it back up. We're gonna try to just go on to the next place, and just try to get them on whenever we can, okay?
Okay. Thank
Great,
you.
Officer Gerard, are you with us? Kristen, I can't see who the other participant is. Is that Officer Gerard?
Yep, Officer Gerard, I am here.
All right, so I don't know if you've heard any of that, but we had an internet outage. I don't know if you guys did
Yep.
too.
Oh yeah, we did as well. I was a little worried I was gonna miss it. I'm like, oh, I don't want to miss this, but
No, absolutely. No, we're trying to get it back together. So we're gonna try to see if Hartford will answer now for Montanez, but I mean,
Okay.
if you can just hang around, are you gonna be able to hang with us to try to figure it out?
I'm hanging.
All right, sounds good. All right. We will try our best.
Officer Trusello, we do actually have New Haven here now.
That's not, that means the internet might be bad.
Okay.
For Randolph, right?
For Randolph, yes.
All right, I'll call him back now.
Ah,
I think I just need me, you, and your attorney. Yeah. Let's throw 1 second. Hannah, you're still here, right? Sorry, Attorney Dean. Oh, hold on 1 second.
Oh,
Yeah, you're fine. Kristen, are you there? Oh, you put Hannah in. Yeah, sorry, Peter. Oh, is he not even there? Doing?
I think they said that they were trying to call him down.
Oh, okay. All right, thank you.
Yeah. Good morning, good morning, good afternoon. Good morning.
Good morning, Mr. Randolph. How are you?
I'm all right, how you doing?
And just, I'll get started in just 1 second.
All right.
Measures. Okay, so good morning, I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Jason Randolph, inmate number 292375. Today is Thursday, May 21st, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office at New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Jason, my middle name too?
That's okay. No, you don't have to. That's okay.
Jason Randolph, 292375.
Thank you. So this is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Randolph.
Thank you. So this is a preliminary hearing which has 3 purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Randolph, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, I do.
Thank you. So we're going to go over the procedure for today's hearing. So first I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights. We're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
That's the packet of everything that they, was talking about, yes.
Yeah. Yep. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we'll now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So charge number 1, the condition of drug testing. The charging officer reported that on 4/6/26, you rendered a urinalysis at Chase Halfway House. Your results were positive for cocaine and you denied usage, so your specimen was sent to Redwood Toxicology Laboratories. Said provider confirmed you were positive for cocaine. Charge number 2, the condition of program participation. The charging officer reported that on 12/30/2025, you were referred to the domestic violence per your special parole conditions. Your scheduled intake was on 1/22/26 at Wheeler Clinic, located on Lakewood Road in Waterbury, Connecticut. You participated in your intake and was informed by your treatment provider your schedule would be each Thursday, 5:45 p.m. to 7:15 p.m. Chase Halfway House Chase Halfway House also issued you passes for aforementioned treatment groups. You attended all your sessions since 1/22/2026, and on 4/9/26, you were supposed to attend your domestic violence program. You deviated after leaving work at 4:06 p.m. to head to a check cashing store without an approved community pass from the Halfway House. You were in violation of your Halfway House agreement. Yeah. And then on charge number 3, the condition of obedience to the law, the charging officer reported that on 4/18/26, you were in a verbal and physical altercation with another offender at Chase Halfway House. The incident stemmed from Rosa being in the bathroom too long and you wanted access to the bathroom. Upon Rosa exiting the bathroom, you were seen on video surveillance having words with Rosa. Her Halfway House staff, Ruben, he had to intervene as you were heard saying, "I will fuck you up. I'm going to punch you in the face," and you mushing/pushing offender. You reported needing to use the bathroom and Rosa told you to wait. You waited 20 minutes. You reported when Rosa left the bathroom, he told you, "Yeah, you had to wait for me." You admitted to yelling at Rosa but denied threatening him. You also informed the trooper that you believe Rosa had stolen $40 from you, but you had never reported it to Halfway House staff. CT State Police arrived on scene and conducted their investigation based on their behavior. CSP charged you with the Connecticut General Statute 53A-182, disorderly conduct, and the Connecticut General Statute 53A-62, threatening second. Charge number 4, the condition of no consumption of alcoholic beverages. The charging officer reported that on 3/4/2026, you returned back to Chase Center from your treatment group at Wheeler Clinic. You were given a urinalysis, which was positive for alcohol. Your sample was sent to Redwood Toxicology Laboratories, which was also confirmed for alcohol. On charge number 5, the condition of Halfway House placement. The charging officer reported that on 2/1/26, you were given a community pass to attend church. You signed out of Renaissance East at 10:47 a.m. with a scheduled return time of 12:47 p.m. At 1 p.m., you called the Halfway House to report you were on the corner and would be back shortly. You returned to the Halfway House at 1:14 p.m. When asked why you were late, you responded, "I was on the bus. It ain't no big deal. Why are you making a big deal about it? It's not that big of a thing because I was late." You were unaccountable in the community for 13 minutes. 3/23/26, you were supposed to return to Chase Halfway House at 4:30 p.m. You called the facility at 4:15 p.m. to report you'd be late. You were given a new return time of 5 p.m. Halfway House remained in contact with you by initiating calls at 5:15, 5:30, 5:45, and 6 p.m. to check the status of your arrival. You arrived at 6:03 p.m. You were unaccountable in the community for 1 hour and 3 minutes. On 4/2/26 at 7:48 a.m., you came to the front office of the Halfway House to sign up for your chiropractor appointment at 9 a.m. in New Haven. You could not sign out due to the system rejecting your pass. You were supposed to sign out at 7:15 a.m. in order to catch the bus and on time to arrive for your appointment for 9 a.m. Due to the tardiness of your part, your pass was denied because you would now arrive an hour past your appointment time. Staff tried to explain this to you, but you responded with, "Well, I'm done talking to you, you always extras." You tried to speak with the program director and he requested that you give him a minute as he was dealing with 3 other offenders at the time. Once he was able to speak to you and he repeated the same information for why your pass was denied, you became disrespectful by swearing at the program director. You further stated, "This is why I walk out." That's fucking bullshit. There's always a fucking issue. You know I'll be out, Lou. You know I'll be out. That's why I left the last time. You later returned to the office requesting a common pass to get your W-2. You were informed by staff that common passes are required to be submitted 3 days ahead of time. You became upset again and swore at staff. On 4/9/26, you were supposed to attend your domestic violence program at Wheeler Clinic that you referred to on 12/30/25. Your scheduled intake was on 1/22/26 at Wheeler Clinic, located in Waterbury, Connecticut. You participated in your intake and was informed by your treatment provider your schedule would be each Thursday, 5:45 p.m. to 7:15 p.m. Chase Halfway House issued you community passes to attend your DV group. You attended all your sessions since 1/22/26 as per your special program. On 4/9/26, you deviated after work at 4:06 p.m. to head to the check cashing store without an approved community pass from the Halfway House. On 4/10/26, you were given a pass for work. You were scheduled to return at 5:30 p.m. Staff tried to call you twice at 5:40 p.m., but you did not answer your phone. Staff attempted to reach you via your phone again at 5:45 p.m. and no avail. You finally returned to the Halfway House at 5:55 p.m. You were unaccountable in the community for 25 minutes. On 4/17/26, you called the Halfway House and reported that you'd be 5 minutes late from your usual scheduled return time at 5:30 p.m. Halfway House informed you that your scheduled return time was actually 5:45 p.m. and you wouldn't be late. At 5:56 p.m., you still had not returned to the Halfway House. At 5:58 p.m., Halfway House staff contacted you via your cell phone. You reported you were currently downtown. You were instructed to return to the Halfway House immediately, and you arrived at the Halfway House at 6:23 p.m. You were unaccountable in the community for 38 minutes. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the remand to actual custody. Exhibit B, the parole conditions. Exhibit C, the Halfway House agreement. Exhibit D, the notice of parole violation. Exhibit E, the notice of parolee rights. Exhibit F, the parole violation report. Exhibit G, the incident reports. Exhibit H, the residential discipline reports. Exhibit I, the offender misconducts. Exhibit J, the redwood toxicology report. Exhibit K, the misdemeanor summons and complaint MC 790736. Exhibit L, the criminal appearance bond, and Exhibit M, the CTD DSPP investigation report. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we have. Thank you.
Thank you. And I did receive documents from the defense. They were a little bit close to the hearing, so I didn't get a chance to fully review them. Would you like me to admit them into evidence, or will you be testifying towards them?
If you could admit them into evidence, that would be great. Thank you.
Okay, so I'm going to just take a moment and read it. Well, I'll read this one quickly.
Yeah, and if we're not covering the face, but where the channel is supposed to be right back.
Listen, where is that noise? Do you hear that noise? Is that New
It's in
Haven?
the background of New Haven.
Yeah, that's
Is it? Oh.
Yeah, that's somebody that's next.
Oh, it's with you? Okay, I couldn't see the screen moving. I wasn't sure if it was coming from there. Okay, thank you.
No problem.
So I did receive 2 exhibits from the defense. I'm gonna do exhibit 1 is the letter. Calling this witness letter. That's all right, witness letter. And exhibit 2 is the judicial branch case detail. All right, and we do not have, do you need time, counsel, to submit any other evidence?
No, we do not. Thank you.
We do not have any witnesses. So at this time, it is the defense's opportunity to make a short statement and testify with respect to probable cause and the severity of the allegations.
Yes, thank you very much. I do just want to start by noting some of the history with my client and this particular halfway house involved in the majority of these violations. He reports that there were prior issues when he was there previously while on parole, and that a number of staff members there he felt were intentionally targeting him due to these prior issues. When he was told where he was going and that he was going to be placed at Chase Center, he reports that he did basically everything short of begging his PO to be brought to a different halfway house just due to that prior history and his concerns. He reports there being an ongoing issue once he did arrive there with with his pass submissions where he would put in for a pass, but then be told they didn't receive that at the last minute. He did try to voice his concerns about this to other staff, but continued, unfortunately, to experience these problems there. Concerning the specific charges, as to the first charge, drug testing, I would argue that there's no allegations or evidence that my client failed to comply with drug testing when requested. As to charge 2, program participation, I would argue that there should be a no finding on that charge. Specifically, I would argue the portion of the charge concerning deviating from the halfway house pass does not meet the elements for that specific charge. Additionally, I would just like to ask my client a couple of questions because I do think they're relevant. Mr. Randolph, can you please explain the situation that occurred with the money order on the date that they're saying you had missed your DV class?
Yeah, I had spoke to the counselor and everything for the pass, and they said that I have enough time and that I could go and get the money order because the money order was for the house. I had to pay $150 for staying there at the house for my check. So they told me to go there first and then go to DV class. I got the DV class like 18 to 20 minutes late, so I was past the 10-minute mark of being allowed in, but I attended all my classes. I never missed a class or nothing, but that's the only reason why I was late. So
thank you very much. I appreciate that. I would also argue, furthermore, in addition to this, as my client noted, he did only miss this one appointment. He had been in DV programming since he got back out. It says that he did his first intake January the 22nd, I believe, and he, to my understanding, had continuously attended. This was the only time when he missed, and he did testify as to the reasoning for that. As to charge 3, obey all laws, I would just argue, my client did receive a fully suspended conditional discharge with no additional probation or time to serve, which I think shows that this was not considered to be of a particularly serious nature by the prosecution who made the offer and also the court who did accept that offer. I will note that we did include a statement taken from a roommate of my client in the halfway house where he indicates that he didn't observe any, physical or threatening behavior on my client's end. However, for the sake of resolving the matter, my client was amenable to accepting the state's conditional discharge offer. As to charge 5, halfway house placement, I would note for the 2-1 incident, my client was only 13 minutes late for his return, and he did call the halfway house, as is stated, to give them a heads up that he was going to be late due to the bus. My client does rely on the bus for transportation to and from his appointments and also his work. And there are, unfortunately, some unforeseen delays by, just virtue of the way that system works. But I would argue that, certainly the 13 minutes, I think, is not an egregious variation. And again, he did call to give them a heads up about that. As to the 323 incident, I would note it shows in the disciplinary report for that staff were in contact with my client. They say, quote, constantly throughout the hour he was allegedly running late. And he first initiated a call with them to give them a heads up and then again remained in contact with them throughout. So I would argue this, there should be a no finding on that. This was a situation, again, where he was returning from a doctor's appointment far off in New Haven, ran into traffic on the highway. Again, sometimes there are unforeseen delays, but he was, to his credit, keeping in constant contact with his PO. And I don't think that that's the type, or not necessarily his PO, but the staff at the halfway house. And I don't necessarily think that that's the type of behavior that we should be penalizing when somebody is conscientious and tries to stay in touch and keep someone aware of their whereabouts. On 4/10/26, I will note my client, again, was only 25 minutes late at another situation, was returning from an appointment. The bus delayed him. He did state that he showed staff upon return that his phone was dead, and that was why he was unable to contact them, as he did, typically do the right thing and always contact them. And then as to the 4/17 date, I believe that this was, again, another incident of my client relying on the bus system and running late due to that. But he did, again, call them even prior to being late to give staff a heads up, at least an hour in advance that he was going to be late just due to the way that the bus system was running that particular day. In addition, I would argue that these allegations are not serious enough to warrant revocation of my client's parole. He did, again, not receive any time or probation in court, which I do think weighs in favor of it not being substantially serious. Additionally, he reports doing some positive things in the community. He was engaging in the DV programming through Wheeler Clinic. Again, as you heard, he only missed that one session. He also reports he was doing outpatient services through Wheeler Clinic on his own as well, which he found to be helpful. He was employed working at Percolux and Waterbury. Furthermore, I would note that the evidence submitted by PCS does appear to show that he is someone who tried, I think, to be very conscientious and communicative with parole if he was ever running late or deviating from his return time on passes. Mr. Randolph, is there anything pertinent to the charges or the seriousness that I didn't cover that you want to say at this time? You don't have to, just if there's anything I didn't include.
No.
All right, thank you.
Thank you.
We agree on these. Email posts that way, and just maybe make sure that I get them.
Great. So I am going to announce my findings, Mr. Randolph. So on charge number 1, the condition of drug testing, I'm making no finding of probable cause as the state failed to submit sufficient evidence in support of the charge and the elements were not met. On charge number 2, the condition of program participation, I'm also making no finding of probable cause. Again, the state did fail to submit sufficient evidence in support of the charge and therefore the elements were not met. On charge number 3, the condition of obedience to the law, I am making a finding of probable cause. As counsel's exhibit 2 shows and statements taken today, you were convicted of that threatening second charge when you received that suspended sentence. In addition, the evidence in support of that charge is states exhibits B, F, G, K, and M. Also making a finding of probable cause for charge number 4, the condition of no consumption of alcoholic beverages based on the evidence presented in states exhibits B, F, G, H, I, J. And charge number 5, the condition of halfway house placement, I have separated that charge into different parts, each part associated with a date as charged, and I'm making a partial finding. So I'm going to make a no finding of probable cause for the dates of March 23rd, 2026 and April 9th, 2026, as the state failed to submit sufficient evidence in support of those 2 dates. I am going to make a finding of probable cause on the remainder of the dates of the charge based on the evidence presented in states exhibits B, C, F, G, H, and I. I am also finding that the acts are serious enough to warrant revocation, and I determine that you should be detained while you await that revocation hearing. So what happens next, Mr. Randolph, is that I will let your officer know and the records facility, the records office at the facility know, and we will work on scheduling your revocation hearing within 60 business days of your remand to custody. At that revocation hearing, myself or another hearing examiner will determine if you have violated the conditions of your parole. And if so, we'll make a recommendation regarding the whether or not your parole should be revoked and what, if any, sanctions should be imposed. So that does conclude today's hearing. Do you have any questions?
Sir, I will get in touch with you as soon as I can. I will be out next week, but I'll get in touch as soon as I can the following week. And I will have someone from my office send the case info to ask your PO to submit the needed paperwork. Okay.
All right, so we'll do.
Oh, you're right.
That mean I just gotta.
So now, it'll be about a month or so, give or take, and we will come back for a second hearing. And it's a higher burden of proof for the state at that hearing, and we'll get another chance to argue some of this stuff.
Yeah, and thanks for correcting me, Attorney Jean. You're right. It is a criminal charge, so I do need that addendum submitted by PCS to get that hearing scheduled. Yeah, so once we receive that paperwork from PCS, your charging officer will get you scheduled for that revocation hearing. Okay.
All right. What's PCS?
That's Parole Community Services. Sorry.
That's okay. Yeah, and that's the people you report to in the community.
And Mr. Randolph, my social worker will also be reaching out to get information from you as well.
All right.
Thank you.
This does conclude the preliminary hearing for Jason Randolph, inmate number 292375. All right, we'll see you soon, hopefully, Mr. Randolph, okay?
All right, have a great day. God bless.
You too.
Thank you. Bye-bye.
Medication.
Hello.
Hi, how are you?
Good, how are you?
Good. Who are you looking for?
We're looking for Joshua Montanez.
Oh, perfect. So it went through because we were having problems with it. Can you
Yeah,
just
no,
give me like
Take your time, absolutely.
Okay, thank you.
Yeah, our internet was down also, yeah.
Okay, perfect.
Listen, it's Delgado. Can you send Montanez down? I got the computer started working.
Okay, thank you. All right, he should be coming down shortly.
Okay, thank you.
You're welcome. All set? Yeah. Thank you. Three months at any available. We're gonna have another pro visit for Andy. 11? Yeah, 11:20. There you go. 11:20, great.
Cool. A relative? No, it's my dad's friend.
Oh, okay, well, every Thursday at 5. Guys.
Okay, 33 door. Thank you. Thank you. Yeah. You don't have to run, you're okay. Have a good one.
Boy,
You're done.
you're a superhero. You a superhero? No? Yeah, you are, but. Look at you flying like a superhero.
Last week, Josiah made I'm sure it was. Because issues that goes.
Montanez?
Yeah. You doing okay, Claire? Yeah, okay. I'll be up there tonight, but okay.
Hi, Mr. Montanez, how are you?
I'm good, and you?
Good, we're gonna get started, okay?
All right.
All right, so good morning, I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is
Good morning.
preliminary. Morning. This is a preliminary hearing concerning Joshua Montanez, inmate number 329535. Today is Thursday, May 21st, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Hartford Correctional Center. Can you please state your full name and DOC inmate number for the record?
Joshua Montanez, 329-535.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office for Mr. Montanez.
Thank you. And also present this morning is your charging officer. Can you please identify yourself for the record? Oh, we can't hear you.
Hi, my
Yeah.
name is Keo Gerard.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can't be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Montanez and Officer Gerard, can you both please raise your right hands? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
I do.
I do.
Thank you. So we're going to go over the procedure for today. So first I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
You do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive a written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence submitted against you before this hearing. You have the right to submit evidence on your own behalf. You also have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. If you understand these rights, now you're ready to go forward.
Yes.
We're now going to review the charge that the state, your parole officer, is bringing against you and the information underlying it. So, Officer Gerard, can you please review the charge for us? Number one, absconder.
Yep. Charge number one, absconder. On 4/12/26, you walked out of your only parole approved residence, Central Ave halfway house, without permission or authorization. You failed to return to the halfway house on 4/7/26 or any point thereafter. You made no attempts to contact the halfway house or parole to disclose your location and your whereabouts, and the community remained unknown until 4/28 when you were
Officer
located.
Gerard, can I just interrupt you quickly? So I have a different one. That one that looks like was served upon Mr. Montanez on 4/30, but you guys reserved him on 5/7.
You are correct. I apologize for that.
That's
Hold on.
okay. No problem.
Sorry about that.
That's okay.
Give me one moment. I'm pulling it up.
Yeah, take your time. Thank you.
Yep. Okay. Charge number one, absconder. On 4/7/26, you were re-released to special parole and placed in your only approved residence at 24 Central Ave, Waterbury, Connecticut. At this time, you were instructed on and agreed to all conditions of your special parole, as well as the rules to the residents of the halfway house. Those conditions include that you will live in a residence approved by your parole officer. 24 Central Ave, Waterbury was your only approved residence. On 4/12/26, you left your residence and failed to return. You failed to contact your parole officer, and your whereabouts in the community remained unknown to your parole officer and parole and community services until you were located by East Hartford Police on 4/28/26. Your whereabouts were unknown for 17 days.
Thank you. You've also submitted evidence in support of the charge. Can you please identify the evidence for us?
Yes, Exhibit A, notice of parole violation. Exhibit B, notice of parolee rights. Exhibit C, remand to actual custody order. Exhibit D, PCS signed conditions. Exhibit E, halfway house agreement. Exhibit F, Board of Pardons and Paroles revocation hearing summary from 3/12/26. Exhibit G, decision information summary, and Exhibit F, parole violation report.
Thank you. Counsel, to confirm you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we did.
And I have not received anything from the defense at this time. Do you need time to submit any documents?
No, I do not.
We do not have any witnesses. So at this time, the state is going to have an opportunity to make a short statement and testify with respect to probable cause and the severity of the allegations. So Officer Gerard, any statements at this time?
All I would say is that Mr. Montanez was given the opportunity to be at Central Ave Halfway House as his residence. He, met with staff, met with everyone, and he decided to abscond on 4/12. I made numerous attempts to try to reach out to him and as well as family members of his, in an attempt to get him to return to the halfway house, to return safely. And none of that was taken. He made no attempts to reach out to me or to the parole office. And like I said, his whereabouts in the community were unknown for 17 days until East Hartford police came in contact with him.
Thank you. And counsel?
Thank you. So as indicated, the sole charge here is the absconder charge. At the time Mr. Montanez was apprehended, he had been unaccounted for about 2.5 weeks at that time. He did have some struggles early on with substance abuse, and he made some mistakes here when he left that halfway house, and I understand that. But given the relatively short period of time that he was unaccounted for, I would argue there's insufficient evidence to establish his intent to permanently abscond from supervision. I know he made mistakes here, and he wasn't off to a good start. However, given the charge he's facing here on this violation, I just don't think enough time has passed to establish that he intended to permanently abscond from supervision. Thank you.
Thank you. Any further comments from either side before I announce my finding? No? Okay. Let's just take a moment. All right, Mr. Montanez. So on charge number 1, the condition of absconder, I am making a finding of probable cause based on the evidence presented in stage exhibits D, H, and I. I'm also finding that the acts are serious enough to warrant revocation, and I've determined you should be detained while you await that revocation hearing. So what happens next, Mr. Montanez, is that we'll notify the records facility at the records office at your facility, and then we will schedule a revocation hearing. At that revocation hearing, myself or another hearing examiner will determine whether or not you violated your conditions of parole. And if so, that hearing examiner will make a recommendation about any sanction, or if your parole should be revoked, and if or what any sanction should be imposed. So that does conclude today's hearing. Do you have any questions?
Just so you, Mr. Montanez, my social worker is going to reach out to you to prepare for the hearing, and I will reach out to you as well once you have a date, and I'll let you know so we can prepare, okay?
All right.
So this does complete the preliminary hearing for Joshua Montanez, inmate number 329535. All right, we'll see you soon, Mr. Montanez. Thank you, Officer Gerard.
Thank you.
Thank
Have a
you.
good day.
Hi, Officer Bennick. How are you?
Good. Was I behind? I'm sorry. I was trying to reconnect on the network.
We're all behind. Yeah, I know you just got here, we're on time. So we're going to try to get into Gardner now.
Okay, great.
Thanks.
I was not there.
Kristen, did any of the CEOs come in or did they just answer and walked out?
A CEO came in and connected and then walked back out. I saw them come back to the room for a moment and then like not enter the door.
Has that ever happened to you?
They probably didn't have McNair down and ready to go, but I had called the facility earlier to let them know
They knew we
would
were
be
coming.
that we
Okay.
would be coming and we'd be starting late because of the network outage.
So maybe
they
they're
knew.
just trying to get him. Okay, all right, sounds good. Thank you.
Do we know if he's a mental health 5 again?
Last I checked, he was, so we're gonna wait and
Because that could also be the case. I'll check real quick. Okay, he's still a mental health 5. Oh, can you guys hear me?
Yeah, yep.
He's still a mental health 5. They might not bring him down.
Yeah, we'll see what they say. He was able to speak to his attorney, so I don't know if it's yeah, we'll see, because normally they'll just come in and let us know,
Yeah,
hopefully. Because I think he does want to be here for it.
okay. If
Yeah.
if not, we just do it without him?
No, we'll probably continue.
Yeah, I mean, if they're not gonna bring him down, I'm gonna have to try to get in touch with him to figure out if I can go forward without him, or else I'll have my social worker try to talk to somebody at the facility to see what we can do.
Okay. Well, and that could work out anyway, because then P.O. Richardson would probably be able to participate. And she knows the case better. Obviously, I just read the violation, so.
Yeah, we'll wait
All
and
right, I
see.
guess-
Normally the CEO will come back and tell us if they can't be brought down. But they didn't actually tell us that, because sometimes they say it in the beginning too. So we'll wait and see what they come back with.
Okay. All right,
Okay.
perfect. Well, I'm here.
Yeah, perfect. Thank you.
Yep. What was that? Did he just check the light switch?
Yeah, that's what happened.
Okay.
Officer Trusello, I called the facility to ask if the CO could come into the room for you.
And that's what happened, or again?
No, just now.
Oh, okay. Because I don't know, did you see him? He just walked in and like turned the light off, like flipped the light switch and walked out.
I did, and my contact person at the facility said that the inmate is being brought down.
Oh, okay, perfect.
So
All right.
hopefully the CO can just confirm that.
Okay, perfect. That's awesome. Thank you so much, Kristen. Hi, how are you? Good. We would just wanted to confirm Mr. McNair was going to be able to come down, because we know his mental health level's a 5 still.
Yeah, he's on the way right now, actually.
Oh, all right, perfect. Thank you so much.
You're welcome. You have a great day.
You too.
Just face it for 1 second. Give me your right here. Thank you.
Hi, Mr. McNair, how are you?
Good, how are you?
Good, we're gonna get started, okay?
Okay.
All right, so good morning. My name is Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Frankie McNair, inmate number 420884. Today is Thursday, May 21st, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Gardner Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Frankie McNair, 420884.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office for Mr. McNear.
Thank you. And also present this morning is Officer Bennick, and well, she's subbing in for Officer Richardson, who's your charging officer. So Officer Bennick, can you please identify yourself for the record?
Yeah, Officer Bethany Bennick with Parole and Community Services Mental Health Unit, and for Parole Officer Erica Richardson.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there is probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. McNair and Officer Bennett, can you both please raise your right hands? You solemnly, yeah, there you go. Do you solemnly swear, solemnly, sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
I do.
Sorry, Mr. McNair, I did not hear you. Do as well?
Yeah.
Thank you. So we're going to go over the procedure for today. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
You do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Were you able to receive that notice, Mr. McNair?
No.
Okay. Are you willing to move forward?
Mr. McNear, did you get the evidence?
You might not have.
They didn't give it to you, any of the evidence about what happened?
No.
Well, do you want to continue it, or do you want to go forward today with the preliminary hearing?
I want to go forward.
All right, thanks.
Thank you. You also have the right to submit evidence in support of your case. You also have the right to, you have the right to review the evidence against you before this hearing. You also have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to move forward?
Yes.
We're now going to review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So, Officer Bennett, can you please review the charges for us, starting with number 1, obedience to the law?
Sure. Charge number 1, obedience to the law. On 4/15/26, you were being relocated to the first floor of Aileen O'Connor. After being informed of this move, you came to the lower level of the halfway house. At this time, you began to throw your television and your clothing. You then picked up a glass jar and smashed it against the door of one of the bedrooms, causing property damage. You were noted to be yelling racial slurs during this time. Staff attempted to verbally de-escalate you, which proved to be unsuccessful. You continue to become verbally aggressive and threatening towards staff, stating, "You better find my phone or else," and entered staff's personal space in a threatening manner. Based on your actions, you are in violation of CGS 53A-117, criminal mischief in the 3rd degree. A person is guilty of criminal mischief in the 3rd degree when having no reasonable ground to believe that such person has a right to do so, such person, 1, intentionally or recklessly, A, damages tangible property or another, B, tampers with tangible property of another and thereby causes such property to be placed in danger of damage, and CGS 53A-182, disorderly conduct. A person is guilty of disorderly conduct when, with intent to cause inconvenience, annoyance, or alarm, or recklessly create a risk thereof, such person, 1, engages in fighting or in violent, tumultuous, or threatening behavior, 2, by offensive or disorderly conduct, annoys or interferes with another person.
And then charge 2, halfway house placement.
Charge 2, on 4/28/25, you were placed at the Eileen O'Connor Halfway House in Hartford and signed a halfway house agreement agreeing to abide by the rules of the halfway house. On 4/15/26, you were being relocated to the first floor of Eileen O'Connor. After being informed of this move, you came to the lower level of the halfway house. At this time, you began to throw your television and your clothing. You then picked up a glass jar and smashed it against the door of one of the bedrooms, causing property damage. You were noted to be yelling racial slurs during this time. Staff attempted to de-escalate you, which proved unsuccessful. You continue to become verbally aggressive and threatening towards staff, stating you better find my phone or else, and entered staff's personal space in a threatening manner. Connecticut State Police were contacted, and at this time, you left the halfway house without authorization. You returned approximately 30 minutes later. However, due to your threatening and aggressive behavior, your immediate removal from the halfway house was requested and you were unsuccessfully discharged on 4/15/26. Your behaviors violated your signed halfway house agreement. Specifically, I will not leave the physical confines of the halfway house unless authorized by program staff, and I will treat others with respect and not engage in verbal or physical altercations with other supervised persons, staff, or third parties.
Thank you. The state also filed exhibits that for today's hearing. Can you please identify the exhibits for us?
Sure. Exhibit A, signed parole conditions. Exhibit B, remand to actual custody. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, signed halfway house agreement. Exhibit F, email correspondence. Exhibit G, incident report. Exhibit H, photographs. Exhibit I, Chapter 952 Penal Code offenses. Exhibit J, remand report. Exhibit K, residential discharge report. Exhibit L, Board of Pardons and Parole decision information summary. Exhibit N, Board of Pardons and Parole revocation summary.
Thank you. Counsel, to confirm you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
I did.
Perfect. I did not receive anything from the defense at this time. Do you need any time to submit any documents?
No.
We do not have any witnesses. So at this time, the state will have an opportunity to make a short statement and testify with respect to probable cause and the severity of the allegation. So Officer Bennett, any statement at this time?
Yeah, I just wanted to point out that Officer Richardson did point out in this violation that the reason for moving Mr. McNair in the first place to the first floor was to accommodate his physical needs and personal hygiene needs. So it was done with his benefit in mind and to accommodate him. And that's all I have right now.
Thank you. Counsel?
Thank you. I'm just going to ask Mr. McNair a few questions. So, Mr. McNair, when did you find out your room was being moved at the O'Connor halfway house?
That day.
So, where were you at the time that you found out?
I was at a program.
So
I
you
was
had
at a
gone to,
program.
so you had gone to a treatment program and just came back to the halfway house?
Yeah.
When you came back, what was going on?
He said that you're moving to the first floor and all your property is already in the first floor. And
Okay,
I went to the second floor to my room and they had already packed all my stuff up.
all right.
So then I was looking for my phone because I was trying to get in touch with Jordan, my job coach. And they took my phone.
So after this incident occurred and you left the halfway house, where did you go?
I was looking for Jordan. I went to the program that I went to, Chrysler Center.
The Chrysler Center program?
Yeah,
And did you speak to anybody at the Chrysler Center program?
I did.
Who did you speak to?
The director there.
And what did they tell you to do?
She said to come back to the halfway house because then you'd be charged with absconding.
And did you then go back to the halfway house?
I did.
All right. At that time that this happened, how long have you been at this halfway house?
3 years.
And how are things going? Were things going well at the halfway house up until this incident?
Yes and no. I had my good days and my bad days.
All right, thank you, Mr. McNear. So, Mr. McNear, he has some significant mental health issues, and admittedly, he did not react well when he discovered his room had been moved. He indicated he wasn't notified of this. He just came back from the program and his stuff had been packed up and they had moved him to a different room. And they took his cell phone, his belongings, and admittedly, he did not handle it well. He did briefly leave to go speak to his counselor at the Christmas program. He was told to return to the halfway house, and he did in fact return to the halfway house. He'd been here at this program for about a year, I believe, on parole. According to the PBR, he'd been engaging in treatment and he'd been doing well. The PBR indicated that he didn't have any misconducts during this period of time since he was released about a year prior. So if there's a finding of violation here, I would argue it's not serious enough to warrant revocation. He did overreact due to the surprise, but prior to this incident, he'd been doing very well for a fairly extended period of time. And he's apologetic for what happened. He knows he didn't handle it right. He knows he has to work on some of his issues to handle things better going forward. But he certainly is amenable to continue working with parole and getting back into treatment. I know individuals suffering from significant mental health issues, they often overreact and respond poorly to unexpected circumstances. And I think that did occur here. But ultimately, he did calm down and he made the right decision to come back to the halfway house fairly quickly. I know since he's been incarcerated here, it's been difficult for him. I know he fell in his cell. He had a fairly significant injury. They had to take him to the hospital. He indicated there's been some issues with his medication as well since he's been remanded. So I think he has demonstrated an ability to work with parole and address his issues on parole. And other than this one isolated incident, his past time being released, he's been doing very well. So I would ask for him to be allowed to continue working with parole and addressing his needs in the community. Thank you.
Thank you. Anything additional, Officer Bennett?
Yeah, I would say that P.O. Richardson did point out in her violation report that he has absconded 3 times so far from supervision. And while he was at Eileen O'Connor for approximately 1 year, he did not have any misconducts, which means he willfully chose to act out in a violent and aggressive manner. Regardless of whether or not staff moved his property without him knowing, you're still responsible for your behaviors and your reactions to situations. And that's all I have.
No, nothing else there.
Thank you. All right, I'm just going to take a moment before I announce my findings. So I have listened to the testimony today. With that, Mr. McNair, I'm going to make a finding of probable cause on charge number 1, the condition of obedience to the law based on the evidence presented in State's Exhibits A, D, F, G, I, J, and K. And on charge number 2, the condition of halfway house placement, I'm also making a finding of probable cause based on the evidence presented in State's Exhibits A, D, E, F, G, J, and K. I am going to find that the acts are serious enough to warrant a revocation, and I've also determined he should be detained while you await that revocation hearing. So what happens next, Mr. McNair, is that we're going to get you back in for a revocation hearing. At that hearing, myself or another hearing examiner will determine whether or not you violated your conditions of parole. If so, that hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. That does conclude today's hearing. So we'll see you probably in the next few weeks. Okay, Mr. McNair?
So, Mr. McNair, I'll be in touch with you and my social worker will be in touch with you to prepare for the revocation hearing, okay? We'll let you know when we get a date.
All right.
This does conclude the preliminary hearing for Frankie McNair. I mean, for 420-884. Thank you, Officer Bennett. We'll see you soon, Mr. McNair, okay?
Thank you.
Thank you. Thank you, Attorney Matthews.
Good morning. I'm Hearing Examiner Meister, and today's May 21st, 2026. Can the board members please state your names for the record?
Joy Chance.
Nancy Turner.
This is a final revocation review for Aponte George, number 396904. I recommend a revoke with a repro date of 12/11/2026 with the following conditions: halfway house placement, no contact with minors, no consumption of alcoholic beverages, no contact with victim A, E, and SE, problem sexual behavior treatment. Does the board accept or reject this recommendation?
Are there any objections?
None.
Okay, we review the findings and recommendation, and so I move to adopt the hearing examiner's recommendation. Do I have a second?
Second.
All those in favor say aye.
Aye.
Motion carries.
This includes fund review for Aponte number 396904. Good morning. I'm Hearing Examiner Meister. Today is May 21st, 2026. Can the board members please state your names for the record?
Joy Chance.
Nancy Turner.
This is a final revocation review for Ray Nissan number 435191. I recommend a revoke with a repro date of August 27th, 2026 with the following conditions: halfway house placement, no consumption of alcoholic beverages, no contact with victim SR or her family, problem sexual behavior treatment, and mental health treatment medication compliance. Does the board accept or reject this recommendation?
Any objections?
I would be interested in adding enhanced internet and device monitoring, given the nature of his refusal and the technical violations. Otherwise, I accept.
That's the second.
I don't have any objection.
Okay. So we review the findings and the recommendation and approve to adopt them with the addition of enhanced monitoring based on the refusal of the offender to follow proper protocol. Do I have a second?
Second.
All those in favor?
Aye.
Motion carries.
This includes review for Ray number 435191. Good morning. I'm Hearing Examiner Meister. Today's May 21st, 2026. Can the board members please state your names for the record?
Joy Chance.
Nancy Turner.
This is a final revocation review of Rodriguez Lewis, number 235238. I recommend a revoke with a repro date of January 27th, 2027 with the following conditions: behavior management program for anger management, general no contact with boss cost 480 Lewis Ave, Meriden, and mental health evaluation. Does the board accept or reject this recommendation?
Before we do that, was there another, I thought there were more than one place, maybe. No, it's another one. Okay, any objections?
I would like to see halfway house added if needed. He's got a friend that he wants to sponsor to, but a lot can happen in the next 7 months. So to avoid a case review, let's just make it halfway house if needed.
Okay, so we review the findings and recommendation and approve and adopt them with the addition of a halfway house stipulation if it is needed. So I move to adopt the hearing examination with the addition. Do I have a second?
Second.
All those in favor?
Aye.
Motion carries. I vote aye.
This includes review for Rodriguez, number 235238. Good morning, Hearing Examiner Meister. Today's May 21st, 2026. Can the board members please state your names for the record?
Joy Chance.
Second.
Nancy Turner.
This is a final revocation review for Seno Matthew, number 376557. And I would like to note that this sentence that he's currently serving is 8 years, execution suspended after 3 years. As there was a typo, so just to note that. So this is, I recommended a revoke with a repro date of 6/3/2026 with the following conditions: halfway house placement, behavior management program for domestic violence, and no contact with co-defendant David Coyer, no contact with victim ZC, and a general no contact with AC without PO's permission. Does the board accept or reject this recommendation?
Any objections?
No, I just wondered if you all had any thoughts about stipulating a stay away from that CVS where the victim was working. I know he's planning to go to Bridgeport, so Southington is pretty far away from that, but if he's as intent as he appeared to be to harass this person, and they, it's just next month, so I didn't know if we wanted to restrict his access to that CVS.
I thought about that, but he's not going back to the same. What are your thoughts on that one, Alex? Because I didn't think.
Well, it's about the victim, not about the store itself. It's just where she works.
I don't have any objection to adding that. Do you have the address for it?
Yes. 326 Main Street.
Okay.
What town is that?
Southington.
Southington.
So
Okay. So we'll review the findings and recommendation, and we're gonna approve and adopt them with the addition of stay away from the CVS located at 326 Main Street in Southington. Do I have a second?
Second.
All those in favor?
Aye.
Okay, motion carries.
this includes 70% on number 376557. Good morning, hearing examiner Mike here, today, May 21st, 2026. Can the board members please state your names for the record?
Joy Chance.
Alex Sarko.
Nancy Turner.
This is a final revocation review for Vega Nelson, number 369427. I recommend a revoke with no new hearing date with an EOS date of 7/14/2026, which is approximate 4-month sanction. Does the board accept or reject this recommendation?
I accept.
Accept.
Okay. So I move to adopt the hearing examiner's recommendation. Do I have a second?
Second.
All those in favor say aye.
Aye.
Okay, motion carries.
This includes the final review for Vega, number 369427. Thank you.
Thank you.
Good morning, my name is Parole Officer Renard. Today is Thursday, May 21st, 2026. This is a case hearing to set parole stipulations for Randy Apaya, inmate number 439185. Board members, please state your names for the record.
Joy Chance,
Alex Sarko.
Nancy Turner,
Board of Pardons and Paroles Interstate Unit is requesting that the immigration detainer condition be added. At this time, the panel will now deliberate.
yeah. So at the request of Parole and Community Services, they're requesting to add an INS detainer. Any objections?
no,
I move to accept the request of Parole and Community Service to add an INS detainer to appear Randy, inmate number 439185. Do I have a second?
Second.
All those in favor say aye. Aye.
aye,
Motion carries.
This concludes the case review hearing for Randy Apaya, inmate number 439185. Good morning, my name is Parole Officer Renard. Today is Thursday, May 21st, 2026. This is a case review hearing to set special parole stipulations for Kevin Badra, inmate number 425177. Board members, please state your names for the record.
Joy Chance,
Alex Sarko.
Nancy Turner,
PCS is requesting that a halfway house placement condition be added. This time the panel will now deliberate.
are there any objections? It's to add
No.
a halfway house. I move to accept Parole and Community Service request to add a halfway house. Do I have a second?
Second.
All those in favor say aye.
Aye.
Motion carries.
This concludes the case review hearing for Kevin Badra, inmate number 425177. Good morning, my name is Parole Officer Renard. Today is Thursday, May 21st, 2026, and this is a case review hearing to set parole stipulations for Alan Karen, inmate number 390392. Board members, please state your names for the record.
Joy Chance,
Alex Sarko.
Nancy Turner,
PCS is requesting that the halfway house placement condition be added. At this time, the panel.
are there any objections?
none,
I move to accept Parole and Community Service request to add a halfway house stipulation. Do I have a second?
Second.
All those in favor say aye.
aye,
Motion carries.
This concludes the case review hearing for Eric 390392. Good morning, my name is Parole Officer Bernard. Today is Thursday, May 21st, 2026. This is a case review hearing to set special parole stipulations for Cordelio Gonzalez, inmate number 305706. Board members, please state your names for the record.
Joy Chance,
Alex Sarko.
Nancy Turner,
PCS is requesting that a halfway house placement condition be added. At this time, the panel will now deliberate.
any objections?
no,
I move to accept Parole and Community Service request to add a halfway house stipulation. Do I have a second?
Second.
All those in favor say aye.
aye,
Motion carries.
This includes the case review hearing for Julio Gonzalez, inmate number 305706. Morning, my name is Parole Officer Renard. Today is Thursday, May 21st, 2026. This is a case review hearing to set parole stipulations for Alan Mason, inmate number 249340. Board members, please state your names for the record.
Joy Chance,
Alex Sarko.
Nancy Turner,
PCS is requesting that a general no contact with CVS at 123 Church Street, New Haven, and a mental health evaluation condition be added. At this time, the panel will not deliberate.
so I thought that should be a stay away from the CVS at 123 Church Street and the DOCS walk-in clinic at 936 Chapel Street, also in New Haven.
I think it's 926, but yes, I do support both of those.
Oh, is it 926? Wait. It says 936.
Okay, my mistake then.
Okay. So I move to accept parole and community service requests to add a mental health evaluation and treatment as deemed necessary, and a stay away from CVS 123 Church Street, New Haven, Connecticut, and the DOCS walk-in clinic located at 936 Chapel Street, New Haven. Do I have a second?
Second.
All those in favor say aye.
Aye.
Motion carries.
This concludes the case review hearing for Alan Mason, inmate number 249340.
Mr. Zarkoff, thank you for your heavy lifting.
As always.
Have a great
Thanks.
Thursday.
Thanks, Ms. Turner.
Enjoy the long weekend, everyone.
Okay.